uh, webinar organized by ICSI IIP. At the outset, I thank ICSI IIP for their invitation. I also thank all of you for your participation. So friends, today our topic is an analysis of the commercial wisdom of Committee of Creditors, in short CoC. Okay. So this topic is now, getting relevance or importance day by day as the code of process of the IBC code is going on. This has become a very relevant topic because there are many jurisprudence in favor of this or against this, and now really it get importance. You know what's happening when IBC was introduced in the year 2016. It was said that IBC has four pillars. One is your adjudicating authority. Second one is your IBBI. Third one is IP. And fourth one is IQ. IU, sorry. Information utilities. So, but okay, as you know that maybe some reason that information, functioning of that information utility have not gone up as per the expectation. That's the different thing. But when the process is started under IBC, it is found that CoC also played a very, very vital and important role. And if you ask me, according to me, the functioning of CoC is the foundation of the code, based on which the entire structure is built up. Because if you see the objective of the code, it means whatever the objective of the code is mentioned, everything, CoC is to contribute for each and every objective items. So, if you, this word wisdom has not been defined in the code. There is no definition of the word wisdom within the IBC. And also there is no laws which define the word wisdom. So here, if you see the dictionary meaning of the word wisdom, it states that the quality of having experience, knowledge, and good judgment. So wisdom indeed, comprises of our wisdom indicates, first of all, having experience, good knowledge, and good judgments. So, and if you see the word, the Indian jurisprudence has recognized the word or this statement commercial wisdom as that court will not interfere on the business decision taken by the entity or the management, unless and until it is unreasonable with reference to a person having normal prudence. So unless and until it is so, court will not interfere with any business decision. So if we consider these two at a time, the commercial wisdom of CoC requires, or what should I say, demands the experience, knowledge, and good judgment on the part of the members of the CoC. And that's why I said that it is a very, very, I should not use the word controversial, but very relevant topic nowadays. We will discuss, there are lots of jurisprudence on this matter. So friend, as you can understand that this is not a subject matter of the code. it is rather very subjective things, and the discussion which I will have with you is purely based on the various jurisprudence and also some of my practical experiences. So my request to all of you, please make it an interactive session. I'm sure that since you are also the insolvency professionals, definitely you have faced some issues, or you can share something for this topic, commercial wisdom. So kindly make it an interactive session, and not it should not be a monologue type of seminar. Okay. So with this, I start my presentation. Yes. Is it visible? My presentation. Yes. Okay. Okay. Thank you. Thank you. That's good. How this- okay. So let me make it full screen. Good. So at the beginning, there are some disclaimer from my side, like the view which has been expressed in my presentation or the interpretation which has been made are purely my personal. Okay. So it is possible for somebody else to interpret or express his view. That's why I also request you, please express your view. You please interact differently. And in case of any legal requirement, I will suggest you that please consult your legal counsel for that matter. Okay. So before I start, I want to discuss with you the advent of Insolvency and Bankruptcy Code 2016. I mean, what necessitates the government of India to brought this code in the country? So is it so that there were no such laws or acts which deals with the insolvency matters at that time? Or is it so that that the laws which are there are not up to the mark? So, I'm sure that you heard about the ease of doing business. These indexes are published by the World Bank, but I think they have now stopped it. Last indexes they have published in the year 2022. So, but this index indicates a very vital thing. This index shows the preferred destination for investment. There are certain parameters, and these parameters indicates the country or the place which has the ease of doing business, where the investor who put their money feels comfortable to do so. And friends, the position of India, I mean, jumped significantly as per the index which published last time, that is in 2022. India's position was earlier, I think it was 149, 143, sorry. We jumped up to the position of 49th position. So you can understand the Indian economy, I mean the atmosphere or the environment of the Indian economy is such that investors, foreign investors or any investor in that sense, consider that the doing business is very easy in this country. And what was the reason for it? In the recent past, Government of India has, I mean, introduced several laws, I mean, beautiful laws and acts. To name one is the GST. Second is the various amendments made in the Companies Act, which really is very helpful for the investors to do business in this country. And another very important laws or act which you can say is this uh, Insolvency and Bankruptcy Code. Sorry, just a minute, sorry. I'm sorry. So what I am saying that this Insolvency and Bankruptcy Code is also considered one of the, I mean, very important law or act which is introduced by the government of India towards the, I mean, comfortable scenario for the business scenario, business phase. So earlier also there are several laws and acts, but the problem was that all these laws or acts are, I mean, independent to each other. They are not complementary. So what's happened, it was possible for a litigant, if he finds subsequently that maybe the order will come against him, he can take the shelter of other law or other act and file a fresh, I mean, petition under the scope of that law. So as a result of which, first of all, the legal process becomes very complicated. It becomes a time, I mean, when a time-bound process, very long, lengthy process. And as a result of which it becomes a costly process also. So this is the first time Government of India, I mean, made the endeavor to find out a single law, a consolidated law, consolidate all the existing framework of insolvency matters and make a single law through this Insolvency and Bankruptcy Code. Okay. The Insolvency and Bankruptcy Code were introduced in Lok Sabha in December 2015 and got the consent from the President of India in May 2016. And as you all know that it has become effective from December 2016, precisely from 1st December 2016. It has been made as one-stop solution for resolving insolvencies, what I just now said, which is a long process and does not offer an economically viable arrangement area. Because of the lengthy process, of course, you can understand the cost involvement is also very high. And as a result of which, many people, they really don't venture to go for the litigation. Yes. So I think you all of you heard about this Sikh Industrial Company Special Provision Act, SICA in short, the Presidency Town Insolvency Act, Provincial Insolvency Act, Companies Act also. There are still provisions for the winding up of the company, SURFACE Act, etc., etc. So all these acts or laws are available before the introduction of bankruptcy code. But what I just now say that because of their individuality, there is no connection between one act and another. It has become a very ineffective law, which India had prior to this code. IBC was framed with the intention to expedite and simplify the process of insolvency bankruptcy proceedings in India. It strives to protect the interest of stakeholders and make the process doing business an efficient task. Not only that, the ease of doing business, that parameters which were there in that ease of doing business also incorporate the parameters for ease of exist. You will appreciate that not all the entity becomes insolvent, or what should I say, come under the purview of the code because of the malign intention of the promoters. There may be some genuine reasons also. For example, if you consider the hospitality sector, the companies which are under hospitality sector during COVID time, they came under IBC, purview of IBC because of the various restrictions imposed at that time on the traveling. You get me? So not necessarily it is the malified intention of the promoter. So this code also provides the scope for ease of exist. So if the promoter finds that he has entered into an unviable business scenario, he can exit the business as quick as possible through this code and thereby can save the losing money in future. Okay, but that is different thing. I'll not discuss these things here. That is different thing. So you know that it provides a strong insolvency framework where the cost and time incurred is minimized in attaining the liquidation. So this is the reason mainly for which the code has been introduced by the government of India. Yes, this is one of my very favorite slides. I personally think if you want to see the scope, or if you want to analyze any action out of the IBC, out of this code, you must have the good understanding about the objective with which this code has been introduced. Not only IBC, according to me, if you want to see the functionality of any law or act, what exactly the purpose for which this has been brought into, I suggest that one should go and first read the objective of that code, of that act. So generally this objective part is provided in the preamble section of the act or law. So if you see the objective of IBC, it is mentioned that an act to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate person, partnership firm, individuals. So friends, you can understand this has now become a single law. This is now the single law. Unlike the earlier laws or act, in a time-bound manner. What we have seen earlier that, the litigation, the process of litigation keeps on going on. But here is the first time the court said that, look, there is a particular time by which you should complete the process. Okay, I am not discuss the practicality of what is happening, but okay, even then, the time which is taken for this is much, much shorter than which we have in the earlier vision. For maximization of value of assets of such person, to promote entrepreneurship, it is very important. And that's why I said that this is one of the very good laws introduced by the government for which the position of the position of India has improved in the ease of doing business index, because first time this law says that, okay, look, it is not only the stopping the activities of the entity. If a company comes under the purview of the insolvency, or comes under the purview of the IBC. First thing, as you are aware, that the insolvency professional tries to revive the company, and thereby it promotes the entrepreneurship. Some new promoter will come with some new idea, he can revive it. Availability of credit and balance the interest of all the stakeholders, including alteration in the order of priority of payment of government. Yeah, I think you all aware of the waterfall mechanism where, earlier the first payment after liquidation from the liquidation proceeds made to the government. This is the first time the court says, no, it is not the government. I think government position is 6 in that waterfall mechanism. So this is the objective with which the code is introduced for providing an effective position scenario in this country for the business purposes. Okay. And as a result of which, this code has some unique propositions. Unique proposition means by these propositions, this code can be differentiated from the earlier ones which exist in our country. Like firstly, it is a consolidated law. Secondly, it provides for a time-bound process. The first time the Act itself mentioned the time period in it. You are aware that section 12 talks about the insolvency process period. Maximization of asset value, definitely, yes, because since it is a time-bound process, and the more time it takes, more the value of asset depletes. Promote entrepreneurship, we have already discussed. Credit availability and balancing interest of all. Friends, this is a very, very important, proposition, or you can say very, very important objective of the IBC code, because our discussion topic totally based on this particular objective, mainly on this particular objective, balancing interest of all. I have already told you that as per the dictionary meaning, wisdom means that quality of having experience, knowledge, and good judgment. So commercial wisdom of CoC really demands for the good judgment apart from the knowledge and experience by which the interest of all stakeholders can be balanced. Okay. So I will not discuss with the entire that how the formation of CoC, because I know that all of you know this thing. But I want to I put those things here which according to me have a direct bearings on the commercial wisdom of the CoC. I will explain why I considered this. That this particular thing has the direct bearings on the commercial wisdom. So if you see section 21(1) of IBC, the interim, as you know that, just very briefly, I just want to discuss you the procedure, that all of you know that there are 3 ways the application for commencement of insolvency can be made. First one is section 7 by the financial creditors. Second one is section 9 by the operational creditors, and section 10 is by the corporate debtor itself. So once the application is filed and the adjudicating authority finds everything is in order, all the documents which are required, everything is submitted. So it passed an order admitting the petition and order for the insolvency commencement for the company, corporate debtor. And once the order is passed, in the same order, adjudicating authority appointed an insolvency professional as the interim resolution professional. to conduct the process initially, and also asked him to make a paper advertisement. In fact, in two papers, one is in English newspapers and other is in vernacular language. So in two newspapers, that Interim Resolution Professional, in short IRP, IRP is required to publish advertisement, first of all informing all the claimants of the corporate data that the company is now under CIRP process, and also invites claim from them with a specified period of time. They look, you submit your claim within this time. Okay. So the interim resolution professional, or IRP, after getting all claims, he constituted a committee of creditors with all the financial creditors. Here the members of the CoC are all financial creditors who have filed their claims, and except the related party of the corporate debtor, even if he is a financial creditor, he will not be considered as a member of CoC. He will not be included in the CoC. And I think this is the very beginning of the concept of commercial wisdom as provided in the code. From the very beginning, excluding the related party. Because again, you see that definition, that having quality knowledge, experience, and good judgment. Definitely, yes, related party cannot provide the good judgment. The first meeting of, and another very important thing, or what should I say, very beautiful thing of this code is that this is the first time what's happening, the ownership has been transferred from owner-driven company to creditors-driven. So because of this particular feature in IBC, again, this commercial wisdom really is impacted. Now it is the CoC who plays a very vital role in insolvency process, not the existing management. As you know, the existing management board is now suspended. So creditors-driven company, it becomes a creditor-driven company, and therefore it requires from the CoC to play the commercial wisdom. Okay. The first meeting of CoC is required to be held within 30 days of ICD, insolvency commencement date, where the resolution professional is appointed by the CoC to carry on the insolvency process for the corporate debtor. Friends, according to me, this is the first issue where the CoC exhibits their commercial wisdom. You know, there are many case laws where, here, you know that either CoC can appoint the same IRP as the RP, resolution professional, or they can change the IRP and appoint somebody else as the resolution professional to carry on the insolvency process. And there are many jurisprudence where it is said, where it is the commercial wisdom or the action of the CoC is challenged. And courts said that, okay, the reason that he is not empaneled with me cannot be a valid reason for replacing the IRP from RP. So this is the first point. When the commercial wisdom of the CoC is coming to picture, appointment of RP. The commercial wisdom of CoC is substantial factor which needs to serve the purposes of the code as depicted in objectives. We have already discussed objectives, and really it is now the commercial wisdom has now become substantial factor. If it is not played correctly or if there is any unreasonableness, the objective of the code will be defeated. Again, I just touch upon the points which according to me have the impact on the commercial wisdom. Okay. A resolution professional may convey a meeting of the committee as and when he considers necessary and shall convey a meeting if requested that the effect is made by members of committee representing 33% of the voting shares. So you can understand or you may appreciate the provision of the code that if 33% total voting share of CoC advise the RP to call a meeting, he has to call a meeting. So, in order to provide good judgment for the insolvency process, court has given this power to the CoC members. If they feel so, with 33% voting share, they can advise the resolution professional to calling a meeting. The first meeting of CoC, the intermediate shall hold the first meeting of the committee in 7 days. These are all provision for achieving that time objective. Notice of the meeting. A meeting of the committee shall be called by giving not less than 5 days. Also, this is mentioned in the code itself because it aims to provide sufficient time to the members of CoC to judge the scenario, to consider the issues, to consider the matter, so that they can deliver the good judgment, which is one of the factors of the commercial wisdom. Every participant at the address it has provided to the resolution professional, and such notice may be sent by hand delivery or by post or served. Okay. The committee may reduce the notice period from 5 days to such other period of not less than 24 hours. Again, I think this provision in the code is made to, what should I say, to have a ground to empower the CoCs to play their roles. Because, it mentioned that generally it is 5 days, but CoC may agree. So if the urgency of the situation so demands, so if CoC feels that, okay, due to the matching the objective of the code, we must have the meeting at a shorter notice, they can advise the resolution professional to do so. But okay, there is a 24 hours timeline is mentioned at the center. Then again, the content of notice. It is categorically mentioned in the code what will be the matters to be mentioned in the notice itself. List of matters to be discussed. So, beforehand, the CoC members understand what are the topics to be discussed. A list of issues to be voted upon also. Not only the matters, which are the items which requires the voting from the CoC also meant to be mentioned in the notice itself. Copies of all documents relevant to the matters to be discussed and the issues to be voted upon at the meeting. Okay, the code also provides some immunity to the resolution professional for providing the notice. They said if it transmits through email and if it is gone out of the mailbox of the resolution professional, he will not be held responsible for a failure in transmission beyond its control. Okay. Another, I think, very important point is the quorum. It categorically said at least 33% total voting rights are present either in person or video conferencing to form the quorum for the meeting. So if you want to exhibit your commercial wisdom, there should be sufficient number to be presented in the meeting. And court says that it should be 33% of the total voting share. Not the numbers, voting share, 33%. So I think this is also in favor of the providing the commercial wisdom by the committee of creditors. Then conduct of the meeting on the minutes, the all meetings of the committee shall be conducted by the resolution professional, and he shall act as the chairperson of the meeting of the committee. So in order to judge the authenticity of the members who are present in the meeting, the court said that there should be a roll call made by the resolution professional who becomes the chairman. And after the roll call, the resolution professional should declare that there is sufficient quorum. It is to be mentioned in the minutes that look, there was sufficient quorum, presence of the commercial financial creditors in the meeting. The resolution professional shall ensure the minutes are to be made in relation to each meeting of the committee, and such minutes shall disclose the particulars of participants who attend the meeting in person through video conference. The resolution professional shall circulate the minutes of the meeting to all participants by electronic means within 48 hours. If the minutes are circulated there is a time gap. If there is a time gap between conducting the meeting and sending the minutes, many things will go out of the head. I mean, CoC will not be able to, what was the actual discussion, or what was the actual decision made in the meeting. So the court says that within 48 hours, these minutes should be circulated. Otherwise, provided separate provision in the code, all decisions of the CoC shall be taken by a vote not less than 51%. But as you are aware, or as you know, that for the resolution, approval of the resolution plan, or for the replacement of the resolution professional, it requires 66%. So the good judgment will come because of the more involvement of the members. And it is not the vote cast, it is the total vote. Okay, the provision is there that if somebody abstains, then it will be counted as the, negative vote, but that is different thing. But court said that it should be vote casted. And for those critical things, court said that it is 66%. And also, that 12A, which deals with the withdrawal application subsequently. Court said that it should be 90% of the total vote of the CoC once the CoC is formed. So according to me, all these provisions are inbuilt in the code to encourage or to provide for the good or genuine commercial prudence or commercial wisdoms from the part of the committee of creditors. The resolution professional shall take a vote of the members of the committee present in the meeting on any item listed for the voting after discussion on the same. At the conclusion of a vote at the meeting, the resolution professional shall announce the decision taken on items along with the names of the members of the committee who voted for and against the decision. So everything should be, transparency should be maintained in that process. Each creditor shall vote in accordance with the voting share assigned to him based on the financial debt owed to each creditor. The resolution professional shall determine the voting share to be assigned to each creditor in the manner specified by the board. Action, I'll discuss with you a little bit in detail, because this section 28 transactions this really require this really demands the commercial wisdom from the COC. So all the actions to be taken under section 28 must be listed in your, must be discussed in the minutes of the COC and should be voted. In any action other than those listed in section 28 remaining requiring approval of the committee may be considered in the meeting. So other also can be taken into the minutes or meeting for discussion purpose. Not only those, this section 28 matters only. The resolution professional shall circulate the minutes of the meeting by electronic means to all members of the committee within 48 hours. We have already discussed. The resolution professional shall seek a vote of the members who did not vote at the meeting on the matters listed for voting by electronic voting system in accordance with resolution 1626. Just now I told you that, look, it is the total vote. It is not vote casted. So if any member is not present in the meeting, it is, court says that resolution professional should involve him, should take his vote through a electronic voting system. Even if he abstains, then it will be counted as the negative voting. But everybody should express his opinion, his judgment on the issues under consideration. In such a voting shall be kept open. Now this section 28, as you know, and also you know, you have seen in the objective clause of IBC, that what it mentioned, that develop the entrepreneurship. And in order to develop, or in order to achieve that objective of the code, it is most important that the corporate data should continue its operation. Should not be, the operations of the corporate data should not be stopped. It should operate as a going concern. And this is one of the most important responsibilities of the resolution professional, to keep functioning as a going concern for the corporate data. And you know, for this purpose, definitely RP incurs various costs. Court says for this purpose, you have to take the approval of COC. You cannot on your own spend the money with the plea that I have to operate or I have to keep the corporate data as a going concern. So if you see the list of costs which is provided in the section 28, raise any interim finance. So if RP wants to raise any interim finance in excess of the amount as may be decided by the committee of creditors in their meeting, create any security interest over the assets of the corporate debtor for the purpose of getting this interim finance, change the capital structure of the corporate debtor, including by way of issuance of additional securities, creating a new class of securities or buying back of redemption, record any change in the ownership interest of the corporate debtor, give instructions to the financial institution maintaining accounts of the corporate debtor for a debt transaction from such, you know, when the corporate entity goes to liquidation, insolvency process, the RP should open a new bank account. And this account, though it is operated by the RP, but he must have the approval for this with the CS. Undertake any related party transaction, amend any constitutional documents of the corporator if the RP wants to bring change in the MOA or AOA, then delegate the authority to any other person. Dispose of or permit of disposal of shares of any shareholder of the corporate debtor or their nominees or to third parties. Make any change in the management of the corporate debtor or its subsidiary. Transfer rights of financial debts or operational debts. Make changes in the appointment or terms of contract of such personnel as specified by the Committee of Creditors. Make changes in appointment or terms of contract of statutory auditors, internal auditors of corporate debtor. All these things related to functioning, keep the functioning of the corporate debtor as a going concern, and court says that you must have the prior approval from the CoC for this purpose. And you know, this really requires, because you know, if CoC doesn't approve, then what's happened? Then definitely there will be a stalemate. And that objective time-bound process cannot be achieved. So CoC has to play its judgment, has to give the approval very consciously. Okay. So if you see the next para, it categorically said resolution professional shall convey meeting of the Committee of Creditors and seek the vote of creditors prior to taking any of the above actions. So any action, prior approval is required. The above action shall not be approved by the Committee of Creditors unless approved by a 66% vote of voting shares. There everything is voting shares, means the total vote, not the vote casted. Where any above action is taken, so you can understand how much importance the court has placed on the role of CoC for conducting the CIRP process. Where any of the above action is taken by the resolution professional without seeking the approval of the Committee of Creditors in the manner as required in the section, such action shall be void. The court categorically said that if any action is taken out of this A to M without seeking prior approval from the CoC, that action is void. I mean, that is legally not permissible. And the Committee of Creditors may report the actions of resolution professional under subsection 4 of section 28 to the board for taking necessary actions against him under this. So friends, the purpose of my to mention all these things only to establish the functioning of CoC, and which mainly run through the commercial wisdom of law. Okay.
One query is there.
Yes, tell me.
It's operational expenses of a company which is a going concern.
Yes.
How the approval should be taken from the CoC, because it's day-to-day expenses in all financial implications.
Yes, sir.
So how this approval should be taken?
Yes, sir. You see this one. I'm talking 10. Over a period of time, role of powers of CoC has further expanded, and because you know, the more importance, what you said, the more importance is given to CoC for approval. And if you see that IBBI has notified, has amended, and if you see the regulation 31B, inserted by IBBI, amended regulation by notification such and such, they categorically said that whenever over going concern, and notified the seek the approval from CoC for all costs, including going concern costs related to CIRP. So generally, the general practice is that in each and every meeting, you have to submit before the CoC the cost incurred by you. First of all, there is when the CoC process starts, or at the first meeting of CoC approved some budget for this. So every meeting hereafter, you have to submit a statement of the cost incurred up to that meeting. Generally, it is 1 month because it is court says that CoC meeting should be conducted within a month.
Law says it should be a prior approval. No?
I'm coming to that. I'm coming to that. So first of all, you have to submit a statement what cost you have incurred, and then you have to submit another statement of the revised budget. Initially, first meeting you have a budget approval from CoC. Okay, so you have the prior approval from CoC. You incur certain costs which may be within the limit or may exceed the limit. So you place that to rectify by the CoC that cost. And not only that, you submit in the same meeting the budgeted or estimated cost you will be incurring for the next quarter or the next month, whatever. Generally, it is done next quarter. Clear? Is it clear to you? Hello? Is it clear to you?
Yeah, that means you have to get the budget approved
for each and every meeting.
Yeah.
Because of this regulation 31B stipulation. And if you see, it is inserted with effect from 15 to 2024. Very recent regulation insertion.
Yeah.
You have no other way but to take the approval from CoC. That's why I say that now the CoC, it functioning now has become the foundation level for the process. If they don't pay their commercial wisdom properly, entire thing will be standstill. Okay. Any more question you have? Anybody? In the light of this, legal experts are of the view that rather than merely supervising the, what was the observation of the Apex Court, Supreme Court in Swiss Ribbon case? Swiss Ribbon case, the Supreme Court says not only in Swiss Ribbon, I think in that case, the Jarsica, which is related to personal guarantor case. Supreme Court categorically said that the role of RP is only as a facilitator. They are purely under the supervision of the CoC and adjudicating. And that is the importance of this role of CoC. All costs, now all costs of the operational cost will be approved by CoC. Legal experts assert since all costs, including operational costs, are mandatorily approved by CoC, the CoC practically exercises direct control over the affairs of C, rather than merely a supervision. Because now, I mean, in true sense, they are running this process. Through their commercial wisdom, this CoC is running the process of insolvency resolution. Do you agree? Okay. So I stop here for a couple of minutes. If you have any question, you can ask. Anything you want to know, or if anything you want to share. No. Because I am sure that all of you have faces issues. I mean, good, bad, ugly, I am not saying. But definitely you have experienced issues out of the decision, out of the functioning of the CoC. So I request all of you, we can share these things, we can discuss this thing, because otherwise, this is not a subject matter of this commercial subject of IBC code. It is a totally subjective, issue, or what discussion we're, doing is a very subjective one. So unless and until we would express, you come out with your experience or share your experience, you can understand that there is nothing to say more about this. So anyway, as I said, that now it has become very important and relevant aspects for insolvency resolution process. There are many jurisprudence against or for and against this commercial wisdom. And if you see the Supreme Court, the court generally held that the commercial wisdom of CoC is not justiciable. Court will not interfere on the decision taken by CoC unless and until it is unreasonable in the common man's parlance, in the ordinary prudence. So if you see this case, Ramakrishna Forgings Limited versus Ravindra Lunka, tells about the position that pertaining in India relating to the interference of AA with commercial wisdom of CoC. So I put here a very brief fact of the case. If you are really interested, you can go to this. Very interesting one. A CIR process was initiated against ACIL Limited by IBBI. The RA submitted, the RA submitted the first resolution plan after several negotiations. An addendum was submitted to the resolution plan with a raise of payment to the F6. Okay. It was further provided that proceeds to a particular land will also go to the F6. The final plan was submitted by the RA, and later on it was approved by CoC with about 88% total vote. So initial plan came, there are some negotiations, CoC asked for certain increase in their share, it was done, and then CoC approved it with 88% total vote. Thereafter, the plan was submitted before AA for approval. No, there is another point is there. It was further provided that the proceeds to a particular land will also go to the FC. So some increase is made in the plan, and also it is said that there is a particular land of the corporator, then if any proceeds is generated out of that fund, land, it will go to the FCs. Okay. So it is approved with 88% voting share and submitted before adjudicating authority for its approval. But adjudicating authority picked the plan against. It didn't approve the plan and directed the official liquidator to provide the exact value of the assets. The actual fact of this case that there was a huge haircut in this particular matter. I think it was 94% like that. So adjudicating authority said that, look, I want to be sure that how much money will be generated. What is the actual valuation of that land, which is earmarked for the FCs. So they kept the plan in advance. So accordingly, in appeal was made under section 61. All of you know that if any issues arising out of the order of NCLT, appeal can be filed under section 61 to enter appellate tribunal. But the appellate tribunal also upheld the order of NCLT. Appellate tribunal said that, okay, what order passed by NCLT, we also agree to that. So again, as per the provision of 62, if you have any grievance out of the order of appellate tribunal under section 62, you have to file your appeal before Supreme Court. And so an appeal under section 62 was filed challenging the above said orders, both the order of NCLT and LT. I'm just putting the gist now. If you want, really interested, you can see the entire thing. You can study these things. So what was the order of NCLT? What is the order of NCLT? All this. So, basically the issues before Supreme Court was that whether the A was right to go into issues of revaluation while exercising its power. So what NCLT is saying that he has directed the, what NCLT did, he directed the official liquidator to value that land, whether he is justified on that. The fact was of new dispute that there was a clear approval of resolution plan by CoC. So I have already mentioned earlier that the plan was approved by 88%, whereas the required percentage is 66. So now come to the decision of Supreme Court. So in order to provide judgment, in order to make the decision, Supreme Court considered various jurisprudence or case laws prior to this. Firstly, Supreme Court mentioned in his order, considers and mentioned in his order the case Shashidhar versus Indian Overseas Bank, Committee of Creditors of SST and Limited, sorry, mentioned twice. SST India Limited versus Satish Kumar Gupta and others, emphasizing on the point that commercial wisdom is non-justiciable. If you see, very briefly, if you see the Shashidhar versus Indian Overseas Bank, you will find that I think the resolution plan is approved by the CoC. Even it is not, I think it is not within the time frame. Just a minute. So it is not within the time frame, and even then the CoC has approved it. So it was first rejected by NCLT and also, and then Supreme Court says that no, nothing doing. That commercial wisdom will prevail. And in this SST versus Satish Kumar Gupta, the moot point is that here the CoC, they said that if you see the waterfall, it categorically said that secure creditors should be paid, with priority. The first preference is secure creditors, and also first preference definitely the cost. Second, it is the equal share of the workmen for 12 months dues and secure creditors. But here in Satish Kumar Gupta case, CoC said that fine, but the secure creditors will be paid based on their security interest. And in both cases, Supreme Court decides that it cannot be, court cannot interfere. It is non-justiciable. Further reference was made to the judgment of Kalparaj Dharamsi versus Kotak Investment Advisors Limited, stating that NCLAT has erred in position as it doubted the merits of the plan approved by the CoC with sufficient percentage of total vote. In this particular case, what's happened? The CoC approved the plan. I think maybe I am confusing. Here, I think they have the time period by which the plan is required to be submitted, the plan came after that. Maybe, but whatever the matter, the Supreme Court said that NCLAT or NCLT has no jurisdiction to challenge the decision of CoC. Okay. Another reference was made to the matter of Pratap Technocrats Private Limited versus Monitoring Committee of Reliance Infratel Limited and another, wherein it was observed that the legislature of India has departed from the foreign insolvency regime. We have the start, we will discuss this. So what is the position in abroad? But in this particular case, Supreme Court categorically said that the code, IBC code in India, it has departed from that of the foreign country. And the format, that is Indian code, provide any ground for review, does not provide any ground for review of the commercial wisdom. We'll see in the foreign countries, there are some scopes for review by the judicial authority. But in India, according to Supreme Court, there is no ground for review of the decision of Committee of Creditors. So unfair, okay, in the foreign countries, there are the scope. Okay. So what's happened? The Apex Code maintained that it is now well settled that the approval is well within the CoC's domain as to how to deal with the entire debt of the corporate debt. So it is only the commercial wisdom, or it is only the business decision taken by the CoC is only valid. So how to it will be dealt with the corporate debtors debt. Therefore, Apex Code allowed the appeal and orders for and the orders on the challenge were set aside. So Supreme Court set aside both the orders of NCLT and NCLAT. The Apex Code did not send the plan back to NCLT as it will lead to the impediment of the objectives of the code, that is quick and time-bound resolution. This is the first time you can see how, what should I say, how the Supreme Court provided its judgment. Generally, what's happened, the superior authority, adjudicating authority, or superior judicial body, they return the case to the lower one and say, okay, you go through it once again and pass the order as per our direction. But here, because of that time-bound process objective, the Supreme Court didn't written the plan to NCLT. Rather, in the order itself, categorically directed NCLT to pass the relevant order within 3 weeks' time. So, friends, this particular case, you will appreciate that reveals so categorically the importance of or the acceptance of commercial wisdom of CoC. Okay. By going through the order of Apex Code, it is clear that here adjudicating authority was in excess of its jurisdiction, as mentioned in the Supreme Court in its order. What authorities apparently did not prioritize is the fulfillment of the foundational principles and objectives of the code. First is that the time-bound process, quick and time-bound process, and the interest of all stakeholders. This curtails the vision of legislature and thereby the code, which cannot be entertained, and hence Apex Code was mindfully appropriate in setting aside the orders. The Supreme Court is of the opinion that, look, if we allow this, it will be totally against the vision of legislation. With which vision? We have already discussed now what was the compulsion for the government of India to introduce this code. So Supreme Court is also of the same opinion that in this particular case, that if we allow that, it will curtail the vision of legislation and thereby the code. The Apex Code was mindfully appropriate in setting aside the orders as well as interpreting the importance of objective of the code, which cannot be bypassed. When you categorize, you cannot bypass the objective of the code. You have to fulfill. So there are some more pronouncements on the commercial wisdoms of CoC. I said that, I mean, lots of case laws are now available on the commercial today. In the Committee of Creditors of SR Steel Limited versus Satish Kumar Gupta, we have seen that in that Ramkrishna forging case also, the Supreme Court mentioned this order. And according to me, I think it is the first order Supreme Court passed on the commercial wisdom of CoC. It was reiterated by the Apex Code that the extent of NCLT's jurisdiction is to the point where CoC has ceded to abide with the parameters in the provisions of code. So Supreme Court said only if that unreasonableness as per the common parlance, as per the prudence of an ordinary person. So Supreme Court said if only CoC is ceded to abide with the parameters of the provisions, like maximization of asset value, balancing of interest of stakeholders, etc., then only NCLT can step in. Otherwise, no. It opined that a hands-off approach has to be adopted by the NCLT. This is in the Committee of Creditors of SR Steel versus Satish Kumar Gupta. Then in another judgment, Axel Mittal India Private Limited versus Satish. Sorry, I think it is some mistake there. And Swiss Ribbon Private Limited and another Union of versus Union of India. The Apex Code held that CoC role is multifaceted, from the determination of viability of corporate debtor to ensuring that the plan balances the rights of other creditors such as operation creditors. I've already told you, friends, that in Swiss Ribbon, Supreme Court categorically mentioned that the RP only functions only as a facilitator. The main function is done by the CoC and then it is adjudicating. But again, what CoC does on the basis of its commercial wisdom, Supreme Court is of the opinion that there is very little option for the adjudicating authority to interfere. Arun Kumar Jagat Ramaka versus Jindal Steel and Power Limited and another, Apex Code observed that the lawmakers were careful and hardworking to ensure the potency of code remains strong. A clear evidence of same is amendments brought in the legislature. Just now we discussed that Regulation 31B. So Supreme Court is of the opinion that, look, the potency of the code is the main objective, main interest or main intention of the legislature. And for that purpose, they have made all these amendments. And it emphasizes that the innovation from the adjudicating authority or the appellate authority should be minimal and it should not disturb the fundamental principles of the code. So if you see the provisions of the code, yes, the provision of the code also provides very little scope for the, if you see that section 31, all these things, very little scope for the NCLT to, I mean, question the decision of the Committee of Claims. All these judgments clearly state that as long as there is no ambiguity or abdication of provisions of the code or and regulations, the CoC cannot be inquired with matters relating to the commercial wisdom. Your adjudicating authority cannot question CoC on its decision, on its commercial wisdom from judicial review of NCLT or N. Okay. So what we have seen then that Ramakrishna, Acha, do you have any question? Please tell me before I go to this.
Yeah.
Yeah, tell me.
For example, this distribution of the resolution amount, it should be on equitable basis. Whether there is any judgment or precedent.
Sorry, come again. I think that you come again.
There are several categories of creditors: secured creditors, unsecured creditors, operational creditors. And the resolution plan makes the offer to the creditors. There is a restriction that there should be equitable distribution, at least in the same class of creditors, for whatever resolution amount has been offered. Whether the judicial intervention can happen there, or it is also left to the CoC.
No, that's what I'm saying. That look, I have provided you the gist. Yeah. I think you are talking about that Artful Mittal case, isn't it? Yes, case.
Yeah.
So you have to see the entire order. Why he has mentioned this. But the net the Supreme Court said that you cannot challenge. If any decision is taken by the CoC, you cannot challenge it. You have no scope as per the code.
No, because the creditor, financial creditor who is having more than 66% vote, so he may try to pull the maximum benefit out of this resolution process. The other minorities may suffer.
I agree. But you know, that's why you see this observation of Supreme Court, they say categorically they have mentioned. Where I read somewhere, no? They said that they talk about the basic intention of the code. I mean, of the legislature. Supreme Court deals with the basic intent. Why this code comes? That's something you cannot check the objective of the code in isolation. What you are saying, again, I'm telling you, then it requires discuss the entire order of Supreme Court. But I suggest that if you are interested, you please go through it. But at the same time, you cannot overlook the other objectives. Time-bound process, balancing interest of all stakeholders, your promote entrepreneurship. So Supreme Court is of the opinion that look, the basic intention of the legislature is to have a time-bound, have a resolution, a solution in a time-bound manner. Unless and until it is truly, I mean, it is against the objective of code. The adjudicating authority cannot step in, cannot question the because it is provided to them. Commercial wisdom, I mean, application of commercial wisdom by the CoC is provided by the code, by the legislature through various sections, through various provisions, which are embodied in the code itself.
But this minority creditors, so do they have any remedy in this? If they feel that they
can challenge. Again, I'm telling you, this code is evolving one. there are many things settled through the jurisprudence only. If this case is settled, so if any case comes to to you, where something happens, we will have the further slide. Commercial wisdom, Supreme Court doesn't say, because there is a Supreme Court order which says that commercial wisdom doesn't mean the commercial arbitrariness. You cannot read you cannot take decision whimsically. There should be ground. But at the same time, because of you see the Ramakrishna case. Ramakrishna case, what's happening? The plan is there, value is not questioned. And that is, that's why the NCLT put that plan against. So Supreme Court said, look, conscious decisions and with the adequate percentage taken by the CoC, at this stage, you cannot challenge that. You cannot say that I will make the valuation of that land and then it's. Because CoC has taken this. CoC is empowered by the court to take the decision. I'm not advocating CoC for their commercial wisdom. But this is the gist of the observation made by the Supreme Apex Court of India.
That means majority's decision will prevail. So whatever may or not be acceptable to minority.
No, not necessarily. I really beg to differ with you. Again, I'm telling you, we'll see that other cases also. Many cases are there. You can challenge, but provided you have solid, logic that look, you are for the proper fulfillment of the objective of the Supreme Court always says that the objective of the code will get the prominence. So if you can prove through your challenge, through your petition, that look, for this purpose, whatever may be the commercial, whatever you call the commercial wisdom of CoC, but because of this, the basic objective of code is defeated, deviated. Definitely, I'm sure the court, because there are many case laws. Again, I'm telling you, most of the things of IBC are settled through jurisprudence. Okay, maybe subsequently IBBI passes the insert the new clauses or insert the new regulations, but initially it is settled through the jurisprudence. Okay.
Okay.
Anything else? Anybody has any question? Thank you. What is your name? Mr. Vaidya. Mr. Vaidya, thank you. I really want an interactive session because otherwise, it will be a monologue type of thing. I'll just keep on saying. So if you see the international practice on commercial wisdom, if you consider the case of UK, in UK, the Insolvency Act is in place where the insolvency process is called as administration. They don't call it as insolvency resolution process. They said it administration. Objectives of the act are similar to those in India, like rescuing the company as a going concern. So they are also the going concern concept got that prominent. Providing results to the creditors, maximization of the value of assets, and balancing the interest of all the interested parties. So far, it is more or less similar with our IBC. A wide range of powers has been given to the administrator who run the process, who is under the duty to act in good faith and is impartial and independent in managerial affairs of the company. The creditors can form a committee in order to assist the administrator in performing his functions. Whereas in India, the CoC is the guiding seat and RP performs the function of assisting the financial creditors and CS. So you can understand the basic difference comes here. Their administrator is all in all. Creditors may form a committee, but the power of the administrator is supreme. But not supreme, you see here. The legislature of UK has provided the provisions for challenging the conduct of administrator in case the practices go against the interest of creditors or in cases of misuse. So I'm sorry, it is not supreme, but even then, they are not under the supervision of the creditors, like that. Okay. Sorry. There are statements of insolvency practices in place for standardizing the conduct of administrator, liquidator, etc. So there are categorical statements in that are regulations. So UK insolvency law frame the regulations to either to standardize or to control the conduct of administrators or liquidators. So if they don't perform accordingly, they can be challenged, but not under the supervision of the creditors. The UK Creditors Committee has limited role, that is to assist the administrator, this is just other way, in carry out his duties and can only ask the court for appropriate action in case administrator misuses his power. Here. So that Supreme Court said that, look, here there is no scope. Here means in India, there is no scope for judicial interference. But in foreign countries, we'll see the other cases also, other countries also. But, but what we have seen in UK, there is a scope for judicial interference. In USA, Chapter 11 reorganizations or Chapter 7 liquidation. Generally, the insolvency resolution process is governed by the Chapter 11 of their insolvency law. And the liquidation process is governed by Chapter 7 of the insolvency law. Are the main options for the corporate reorganization. Sorry. Chapter 11 deals with the reorganization of the corporate entities in the similar manner as that of CIF, just now I told you, under Indian insolvency regime, while purpose of Chapter 7 is to optimize the recovery of different creditors of the debtors vis-a-vis liquidation. So more or less similar, but they said there is no, Chapter 11 is totally deals with, I think in our IBC also, that insolvency resolution process mainly deals with the revival of the company. If it is not possible, then as according to IBC, as per IBC, it will go into liquidation. Chapter 11 provides for a provisions where the debtor remains in control of the business operations and repays the creditors by reorganization plan approved by the court. Again, but here it is there is a difference. Here we have the, I think in UK also it is not creditor driven, but it is administrator driven process. In India, it is purely creditor driven process, not owner driven. But in USA, the debtor, the corporate debtor, they keep the control over the business and they make a plan to pay the creditors. And that plan should be approved by the court, not by the creditors. The plan what the debtor prepares for the repayment of the creditors, that plan is to be approved by the court. Okay. The US trustees and official from US Department of Justice has the duty of overseeing the development of Chapter 11 case and managing the operations of debtor in possessions business. So though the operations is controlled by the debtor in USA, an official from the US Department of Justice, so direct control of the judiciary. He was entrusted to overseeing the development and managing the operations and how the operation is managed by the debtor. He oversees all this. The court may appoint an examiner to investigate in cases of fraud, mismanagement, incompetence by the debtor. So for all these reasons, there may be an interference by the judicial body. The court can also order the takeover of the management of the debtor's business by the trustee. So now trustee, I think trustee is the clear. US trustee is an official. So in this case, that official of the judicial department will take over the management of the debtor. In this particular scenario, the debtor will lose control over the company or his business. When a trustee is appointed, the debtor forfeits its authority to be in control and is obliged to transfer the management of his business to the trustee. The trustee takes the place of the debtor's board of directors and takes on the responsibility of the business, executive leadership, and administration in a way that is comparable to RP during CIRP in India. Here, after taking over by the trustee, here there is some similarity with the Indian process. Otherwise, it is totally different. Okay. The USA Bankruptcy Code stipulates in section 1129 A7 that a reorganization plan must fulfill specific criteria to be accepted, such as obtaining the vote of at least one impaired class. Impaired class means weak class. In the event of any impaired classes under the plan. So one weak class who are not what just now with the said, so with the said that the minority shareholder, stakeholders, what we do. So this thing is taken care of by the USA provision. Under USA law, a committee of unsecured creditors can be established to advocate for the benefits of all general and secured creditors and maximize their returns. The creditors committee typically assumes an active role in representing the interest of the creditors. The creditors committee plays active role in decision making and fast tracking the insolvency process. So here you can say maybe some similarity with the process, but the basic structure of the USA insolvency law is, according to me, completely different than ours. USA bankruptcy regime is debtor friendly and provides for engaged participation and some degree of power to the unsecured creditors. So this is summary. How the debtors USA bankruptcy laws are operated. Then we will see the position in another country, Singapore. The insolvency process in Singapore is called judicial management and is supervised by the court. So friends, you can see in Singapore, the entire thing is controlled by the court. It is supervised by the court. Similar to the CIRP, the objective of the judicial management process is to rehabilitate financially distressed companies. Okay. Manager, a licensed insolvency practitioner, oversees the judicial management process and has a broad range of responsibilities, including managing the company's affairs, business and property, taking over the director's function, and performing all duties in the best interest of the company's creditors. So though it is supervised by the court, but one licensed insolvency practitioner is engaged to supervise the, continue with the process, insolvency process. The judicial manager carries out the same responsibilities as that of RP, as well as exercise the commercial wisdom of the CoC, all within the overall supervision and active participation of the court. You understand? Though they have the power to exercise his commercial wisdom, or he has the responsibility similar to RP, but everything under the overall supervision of the court. That's why Supreme Court in that particular case, Ramakrishna Forging said that Indian position is not similar to the other countries. A distinction can be observed of the position in India as the function of RP and CoC are conducted but well defined, whereas in Singapore, the judicial manager performs the function of an RP, including the exercise of judicial wisdom. So this is the position of insolvency law in other countries. Again, I stop for a minute or maybe less than that. If you have any question, because now I'll go to a very interesting topic, which rates as commercial wisdom versus commercial arbitrariness. Yes. So as I started my discussion saying that the court will only interfere when this commercial wisdom sounds unreasonable. So any question you have so far, or any input you want to provide, any experience you want to share here? Just I want for a minute. So please feel free to share your experience.
In this evaluation matrix which is made before examining the resolution plan, whether it is binding on the CoC to follow that matrix, or they can have their own decision?
First of all, this evaluation matrix is approved by the CoC. So during the course of approval, they gone through all the discussions. What will be the qualitative parameters, what will be the quantitative parameters, what weightage will be given. So definitely, yes, once it is approved by them only, they cannot deviate. They will not deviate also. Because this is framed by them only.
No, the matrix is framed approved by the CoC, but actually evaluation is done by the RP and then put up before the CoC.
No, sir. You know what's happened? As per the procedure, what's happened? RP only sees, first of all, RP checks the compliance of that section 29A, whether the plan has come from a related party or not. Then RP only see whether all the provisions, then legal scrutiny RP done. But RP has to place all plans before the CoC for acceptance. And CoC evaluate the plan, first of all, with the evaluation matrix. But yes, it is a fact. Because if you say, I think 39A, 39(2)(b), it categorically said that when the plan is approved, the CoC has to record its opinion about the viability and feasibility of the plan. So what you are saying that first of all, CoC definitely evaluate all plans based on the evaluation matrix, but maybe CoC will not approve the H1 plan. Maybe there is a possibility. CoC can, if CoC feels that the feasibility and viability of H2 is more than H1, they can approve. They definitely can approve. And there comes the question of commercial wisdom, isn't it? But CoC cannot, I mean, what should I say? Cannot violate the evaluation matrix. They cannot say, no, I will not evaluate through the evaluation matrix. I'll just approve this plan. No, that is arbitrariness. They have to first evaluate all plans as per the parameter. Then they can play their commercial wisdom that which one is to be approved. They can, many cases are there, they can, they ask the H2 and say that, look, we have this plan from this H1. Are you, I mean, do you want to match them? And many cases it is matched.
So they can encourage the inter-se bidding also.
Sorry?
There is more than one resolution plan, and the CoC wants to encourage the inter-se bidding to increase the resolution amount. So whether
yes, Swiss challenge method, they, of course, CoC can resort to Swiss challenge method. But there are other procedures. These procedures are all mentioned in the code itself, okay? And whatever the CoC does, it should be minted in the minutes. Swiss challenge method, of course, it is possible. They can go. They can say that, okay, I will go for the, I mean, I will give this to the higher bidders. But that I think after selecting a few plans as the feasible and viable, then they can ask the bidder that you increase your price.
It should be one benchmark plan there. So on that they can go ahead with the Swiss challenge method.
And maybe or maybe you know, I mean there are several rounds of this bidding. So next time CoC can also dictate that, okay, I want 5% increase of this. If anybody is interested, you match it. But what was your original question, that whether CoC can deviate from evaluation matrix? According to me, no. First, CoC has to evaluate all the plans based on this yardstick. Because otherwise they cannot establish the feasibility and viability of the plan, isn't it? The basic thing the CoC has to establish that there is a feasibility and viability of the plan which they have approved.
No, that is established. After the establishment of viability only it will come for the decision. But at that time, whether they can have the separate criteria for evaluation or only go by the...
Yes, they can go for the system. Yes. Yes. Suppose they have selected 2 plans and they can say that, okay, you increase your bid. Of course, yes. But I think all these things to be mentioned in the RFRP from the very beginning. When RP issued the RFRP, request for resolution plan, all these procedures should be mentioned. Otherwise, maybe somebody can challenge it, that, okay, there was no mention that the Swiss challenge method will be adopted.
But now, the CoC can deviate from these conditions in RFRP if they feel that particular condition in RFRP should be relaxed or kept aside.
If you ask me, as per all these judicial pronouncements, if CoC decides through its commercial wisdom, it can give it. But definitely, again, it is not a very straitjacket case. Definitely, the other party whose plan is not approved, definitely he will go and file case against the decision of approving the resolution plan of others. So there you have to establish that your reason, your points that why you have accepted these things.
So the affected party can challenge that.
Sorry?
The affected party can challenge that.
Of course, affected party can definitely challenge. Definitely can challenge. But it is open for the CoC to utilize its commercial wisdom. And that is for all these commercial jurisprudence which have discussed also supported this view. The decision came from Apex Court also supported this view. Yes, so long it is within the objective of the court, they can do. And very
equal opportunity has to be given to all the.
Sorry?
Equal opportunity has to be given in case they are making any amendments or changes in RFRP. Then
that's what I'm saying, that if it doesn't deviate, it does not affect the objective of the code, it is allowed. And Apex Code also said that very little scope for the NCLT. Do you mean to say that there is no order from the NCLT to, disapprove the CoC? Of course, there. But definitely that other party, that party also have the option to go for filing appeal in NCLAT. Even if it is not approved by the NCLAT, then he has the option to go to Supreme Court. I just picked up the cases to, what should I say, to support my today's discussion that how the judicial body looks for the commercial wisdom. But here you will see something different. I am going to that. Before that, for your understanding, I want to ask you that whether you have question. Very good, thank you. That whether you have any point or any confusion on this subject. But it is not so. That's why I'm saying that is very evolving subject. And many, again, I'm telling you that many things have been settled through the judicial pronouncement. Many things. Okay. So anyone else have question? Hello? Anybody else have any question? Good. So let's proceed, okay? So if you see here, I am discussing that commercial wisdom versus commercial arbitrariness. Again and again, I am telling you that the code provides for the scope for the CoC to play its commercial wisdom. It doesn't mean that CoC will take decision arbitrarily. No. So the role of CoC has become utmost importance in resolution process empowered with the exercise of commercial wisdom, which plays a pivotal role in deciding the fate of the corporate debtor and balancing the interest of diverse stakeholders. However, the judicial interpretation of commercial wisdom has not been without scrutiny. Very important. It is not that you have filed and court also will support you. Adjudicating authorities hold that the decision of the CoC must align with the legal framework. Most important should be aligned with the IBC code. Sorry, I have not seen this one. Should align with the legal framework of the code and should not be arbitrary or in violation of the established laws, and thereby maintaining fairness and transparency in the insolvency process. There is a provision in 30E, regulation 30, sorry, where it is said that before submission of plan, resolution professional has to see that the plan is abide by all the provisions of law for the time being in force in India. Even if, I mean, bypassing that thing, CoC wants to approve that plan, definitely, according to me, that is an arbitrariness on their part. The Supreme Court India has taken steps in direction by limiting the empowerment of CoC in M.K. Rajagopalan versus Dr. Periswamy Palani Gounder case. So we have seen the Supreme Court cases where Supreme Court held supremacy of the commercial wisdom of CoC, but in this particular case, M.K. Rajagopalan versus Dr. Periswamy Palani Gounder case, Supreme Court has taken steps in direction limiting the empowerment of CoC. Both favor, against. In this case, the submission of resolution plan was in contravention of the Indian law, Indian Trust Act. SC equivocally held that the commercial wisdom of the CoC should not be overexpanded to brush aside a significant shortcoming in the decision-making of CoC, when it had not duly taken note of the operation of any provision of law for the timing in force. So what I just now said, that if the plan contravenes the provision of any law for the timing in operation in India, and if the plan is approved by CoC, it will be treated as shortcoming in the decision-making of CoC because they have not duly taken note of operation of any provision of law for the timing. And in that case, definitely the adjudicating authority will step in. I think in particular cases, what you were saying that the minority stakeholders' interest was not fulfilled by the resolution plan. Even then, the CoC said that yes, we approve this. SC held that the status of CoC would not be a sufficient reason to ignore any shortcomings of the code. Commercial wisdom is accorded a status of primary in the CIR process, subject to the condition that every aspect of the resolution plan is made available for CoC deliberation. CoC must deliberate on all the aspects and should be minutized their decision. Otherwise, it will not be considered as the commercial wisdom. Because, you know, because of this, I mentioned these things in red because I thought that I should discuss on this point to you when I discuss this. Because, first of all, the commercial wisdom of CoC really affects the fate of the corporate debtor. It is CoC who decides whether the revival will be done of the corporate is done or it has to go to liquidation. And if it is done, I mean, not arbitrarily, with proper justification, no one can question that thing. So it is established or it is accepted that fate of the CD is determined by the action of the CoC. Similarly, balancing the interest of other stakeholders also. It is categorically mentioned that what are the essential ingredients of the resolution plan. What the resolution plan should provide. Like to, I mean, make provision for the operational creditors, descending financial creditors. Everything should be, I mean, made crystal clear by the provision of the code and the regulations from there under. So if CoC wants to play its commercial wisdom, just overlooking this thing, but definitely they can give reason. they can substantiate their decision for the feasibility and viability, but at the same time, they cannot overlook the provisions of the existing law for the time being in force and also the provisions given in the code itself. Then that will not be considered as a commercial issue. That will be tantamount to commercial arbitrage. And that is the important. Friends, I really want to discuss these things with you. I really want your experience or your feedback, whether you have faced any such things. Because unless and until it is done, it will be treated as the commercial arbitrariness of the CoC part, and they cannot do it. Okay. SC observed that if the decision of the CoC is in contravention of any law in force, the principle of commercial wisdom cannot be taken as a defense. You cannot, in CoC cannot say, okay, I have taken this decision based on my commercial wisdom. No. SC categorically said if there is a contravention of any law in force, the commercial wisdom cannot be taken as a defense to go forward with the impugned decision. And the same becomes subjected to judicial scrutiny. In this particular case, unlike the other case which I have already discussed, in M.K. Rajagopalan state, SC maintains that in such scenario, it is subject to judicial scrutiny. The Apex Code emphasized that stretching the principle of commercial wisdom too far would overlook a significant flaw in functioning of CoC and attempted to contain principle of commercial wisdom to some extent by providing a regulatory check by the AA under Section 31 of the Code. Section 131, as you know, deals with the approval of the plan. So if these things happen, if the provisions of other laws are not properly taken care of, definitely these are subject to judicial scrutiny as the auditing authority is empowered by Section 31 of the Code. So commercial wisdom, friends, according to me, is not a straitjacket concept. Whatever CoC is doing is the commercial wisdom? No. Yeah. In this particular case, in Converse Sajdev versus IBBI Bank, it is okay, it is decided by Delhi High Court. Observe that with great power comes great responsibility. CoC has great power under the IBC. Therefore, CoC also have great responsibilities under IBC. CoC, which is a pivotal body under regime of CIRP, cannot be devoid of any code of conduct for its functioning and discharging obligations under the provisions of the code. The CoC being entrusted with the fiduciary duty of to bring back the corporate debtor from vicious cycle of debt trap and revive the company. Yes, sir. Cannot be divided of any code of conduct for its functioning and discharging obligation under provisions of the CoC being entrusted with the fiduciary duty, because as per the judicial decisions, the position of CoC is a fiduciary nature. They are the secured financial or financial creditors, but at the same time, they have the fiduciary duty for all the stakeholders as they sit in the committee of creditors. and the company must be saddled with the responsibility of ensuring that the decision taken by it in exercise of its commercial wisdom shall be in tune of bona fide objective of the court. In order to facilitate an effective and responsible functioning of the CoC, an elaborate, determinative, and efficient code of conduct for functioning of CoC assumes great relevance. Here, Delhi Court mentions or imposes the importance of framing and code of conduct for the CoC so that they can play their commercial wisdom in a more, what should I say, structured way or more appropriately. Because if they have the code of conduct, they bound to operate within that code. So in this particular case, the Delhi High Court, opined that there is a requirement of the code of conduct for CoC to avoid any commercial arbitrariness from their part. It is pertinent to mention that the Insolvency Law Committee, in its report dated 20th February 2020, has also recommended a standard code of conduct for the functioning of CoC. It is not only Delhi High Court. In fact, if you see the Law Committee report in the year 2020, they also, give the suggestion to frame a code of conduct. But very unfortunately, very recently, IBBI has issued a code of conduct for CoC, but let's see how much it will be available. It is vividly seen that the CoC takes the driver's seat in this entire voyage of hierarchy of corporate data, and the commercial wisdom of the CoC functions in the same way as the global positioning system works GPS for the driver in the journey, leading the way to the intended destination. So any deviation, any malfunctioning, arbitrariness on the part of CoC, definitely the journey path will be deviated. It will not be possible to reach the proper destination as per the code if there is any arbitrariness or malfunctioning on the part of CoC. So, concerns expressed by A, the adjudicating authority also in various orders, they express their concern over the functioning of the CoC. That's why I'm saying it is not a straitjacket matter that, okay, commercial wisdom, I am in CoC that I can do anything. Express concerns about the conduct of CoC in a number of judicial pronouncements. In case SBJ Exports and Manufacturing Private Limited, DCC Cuba India Limited, A observed that observation was that a strange phenomena had developed in so far as the functioning of CoC is concerned. In a number of cases, it had been seen. Very important. I am sure that you people also face this thing. I have faced. I have no hesitation to say I have faced this thing. The NCLT said that it is observed in a number of cases, it has been seen that the members of CoC were nominated by the financial creditors like bank without conferring upon them the authority to take decisions on the spot, which acts as a block in the time-bound process contemplated by the insolvency and bankruptcy. Dictionary meaning of wisdom is that having quality of knowledge, experience, and good judgment. And good judgment only comes from a timely decision, isn't it? But I'm sorry for my language, but it is seen that in many cases that CoC members say, okay, we'll talk on this internally and then we'll come back. They generally forget that this IBC, that IBC process is a time-bound process. So, according to me, this function of CoC is also arbitrary. It definitely cannot, is not exhibiting their commercial wisdom. Okay, we'll discuss it internally and then come back. No. The person should be empowered enough to take on the spot decision. Then it will be the functioning of, will be fruitful, isn't it? To take decision on the spot, which acts as a block in the time-bound process contemplated by the Insolvency Bankruptcy Code 2016. These speed breakers and roadblocks obviously cause obstacles to achieve the targets of speedy disposal of CIR processes. So, friends, if you see the main concern everywhere, the concern expressed by the judicial authority towards the non-fulfillment of the objective of the court. And interestingly, I can tell you that accordingly, IBBI issued circular dated 10th August 2018. All of us, I think you also do the same thing. When in power, issued a notice, we mentioned this. We referred this circular on the body of the notice that as per the circular dated 10th August 2018, the financial creditor must be represented in the CoC by such person who are competent and authorized to take decision on the spot without deferring decision for the want of any internal approval from the financial. But it is really, I mean, I am sorry to say that this is not happening. I am sure that you will also support this. In many cases, they said, okay, we'll discuss it internally and then come back. Okay. Then concerns expressed by the legal experts. Legal experts have opined that the objective of value maximization during CIR process is defeated if the CD or RP are not provided with timely funding or if they are not permitted to raise interim finance. This is also one of the, what should I say? Point observed for not properly utilizing the commercial wisdom. All of us know that for running the corporate debtor as a going concern, we require fund. RP requires fund. RP requires to raise the interim finance. And you have seen already that in under section 28 for this, all these purposes, it is required the approval, 66% approval from CoC. And for the lack of their commercial wisdom, CoC defers this thing, which suffers, for which the entire resolution process suffers. The time-bound process of the resolution suffers because of this. For example, if you see the determination of avoidance transactions, if you see the provision of the code, it is categorically mentioned that RP should first form his opinion about this avoidance transactions within 75 days of ICD, then make an assessment of this within 135 days, 105 days, I think, sorry. And then make the application to the adjudicating authority 135 days, okay. Absolutely nowhere in the code mentioned that the RP has to take the permission from the CoC for conducting avoidance transactions audit or the formalities for filing application for the avoidance transaction. But the main problem, friends, the fund, the cost. For this, the RP has to bear the cost. And CoC CoC, in many cases, CoC is very much reluctant to approve that cost. As a result of which, RP incurred these expenses from his own on his own. So just see that all the responsibilities which the RP assumes as per the provisions of the code and regulations frame they are under, because of not properly exercising the commercial wisdom, CoC put hindrance on that. Isn't it? Do you agree or not? Tell me. Hello, I am audible. I think I am audible. Hello? I think you can hear me, no? Hello? Hello, I am audible?
Yes, yes.
Okay, okay. So you understand this thing, no? And I am sure that many of you faces this issue. A common grievance of RP is that the fees are not approved. Again, the approval of fees. That also, according to me, comes under the purview of commercial wisdom of CoC. When the excessive fees is definitely not warranted, but the fees which is as per the regulations, as per the framework of the IBC, CoC should be prompt enough in approving that. Prompt enough to approve the cost for running the process. So very casually, friends, we say that the commercial wisdom of CoC is only for the approving the resolution plan. No, according to me, it is not. Commercial wisdom of CoC is required for running the entire CIRP process. Everywhere. That's why I started my presentation by with some provisions which may not be directly linked with my presentation. But for your information, I put those things there because I want to show you that look, the code says so. The court has empowered the CoC to do so. Okay. According to legal experts, by not allowing timely access to funds through the RP, CoC may also bear the vicarious responsibility for non-compliances and the loss of value of assets, as according to the decision of Apex Court in 6 Ribbon, RP acts under the supervision of CoC. So legal expert says that, okay, if the process cannot be completed within the specified time frame, it is not only RP, equal responsibility should come to CoC. And this is more so because the Apex Court says that CoC supervise the function of RP. Okay. So I put some regulations, and you can see from here that very recent regulations are there. I can tell you this has no connection with the subject of our discussion, commercialism. I put this because of, first of all, to show that all these new insertions have indirect bearings on the CIRP process and which can only be fulfilled through the commercial wisdom of CoC. And really, I request all of you, don't, please speak out. Don't make this presentation as a monologue, because I am sure all of you has faced this or have the experience on these regulations. For example, regulation 4.3a, it is inserted with effect from 14/6/2022. mandates that the creditors provide the resolution professional with the latest financial statement and other relevant financial information of the corporate debtor that they possess. This ensures the resolution professional has a comprehensive understanding of the company's financial situation to facilitate the insolvency resolution. However, when CR process starts, the accounts of the CD has already been shifted. Sorry, something here. Shifted to the stressed assets vertical of the bank, which may or may not having the entire, though not have direct bearings, but it is something is the responsibility on the part of the financial creditor, the banks, because this particular regulation categorically mentioned that they should provide the information, financial statements and other relevant financial to the RP to form the opinion. So anyone will speak out that his experience on this. Do you get all the information, financial information or financial statement from CoC members during your conducting the CIRP process? Anyone can say. Then regulation 35A4, it is also inserted on the same date. Because all these things, that is also the observation of the Supreme Court, that many amendments brought into the court to empower the CoC for the conducting the CIP process. So this 35A4 says that the creditor shall provide to the resolution professional relevant extract from the audits of CD conducted by the creditors, such as stock audits, transaction audit, forensic audit, etc. I can share my experience. I asked for these things. I know that particular bank has conducted the forensic audit, but I am very sorry to say I didn't get that report. I didn't get that report. I have to conduct the fresh forensic audit. I have to form my opinion based on the available records in hand. Then I have to engage the forensic auditor and I have to conduct the audit. I asked them, I know that they have they did this forensic audit when the corporate debtor defaulted in making the payment. But even then, I didn't get it. I'm not saying that it is deliberate. Maybe this is because of this reason. Because every bank, they follow the system. Once it becomes NPA, they transfer everything. The branch just wash off his hands and send everything to that stressed asset vertical of the bank. Maybe they have not submitted that. Well, they submit the transfer the documents to that vertical. Maybe. Don't know. But this is my practical experience. Regulation 36A, 3A, inserted with effect from again in the same date. The creditor shall provide the resolution professional the latest financial statement and other relevant financial information of CD available with him. Again, due to the movement. You can see that both the regulation, 4.3a and 36.3a, both the regulation demands from the financial creditors about the financial statement and financial information. Because the thing is, in many cases, the records are not available. And I'm sure that you have also faced that the promoters, since it becomes a creditor-driven operation, they are also very reluctant. And if you file the Section 19 application, it takes, days after day. Dates are following and then actual decision comes after so many days. But you cannot stop with the conducting the CIP process. So I think, okay, again I'm telling you, not directly related to your commercial wisdom. The element of commercial wisdom comes because the CoC should realize, should understand that without these documents, the time-bound process, which is one of the objectives of the IBC code, is very difficult to achieve. Agree? Acha. Can you have some break at this point? Anybody from ICSI, IIT? Hello? What is the time? Can you have 5 minutes break here?
Yes, sir.
Sorry? Hello?
I am from ICSI IIT. No, sorry, sir. I don't know.
Can you have 5 minutes break here? Can you?
Yes, sir. Sure.
Yeah. 5 minutes break. 5 minutes. Just give me 5 minutes.
Miscellaneous expenditure दिख रहा है
So can we resume? Hello? Can we start?
Yes, sir, we can start, sir. Start, please.
Okay, thank you. So we have already discussed, the importance of commercial wisdom, also the, what should I say, that hindrance out of the commercial arbitrariness and the observation of the code to have a code of conduct, established code of conduct for the CoC in discharging its function. And on 6th August 2024, IBBA has issued a guideline for the Committee of Creditors, stating that under the code, the commercial wisdom of the CoC derives the procedures to attain the objective value maximization of the distressed assets. So basically, this code of conduct issued by the board, IBBI, to ensure a proper commercial wisdom on the part of the CoC, so that the objective of the code towards value maximization is achieved. It further states that the members of CoC largely represent financial creditors, and most of them are under regulatory oversight of the financial sector regulator, RBI, other than the board. So the main issue which is realized by now, that generally these financial creditors are the banks of the country, and these banks are generally governed by the regulations, rules and regulations framed by RBI. And that rules and regulations, because if you see, these banks have very clear-cut guidance when to declare an account NPA, what steps you have to take in if the company goes into if the company's account is adjusted as an NPA, all these things, because these guidelines or procedures are issued by the RBI towards this purpose. But the control or regulatory control of the board, though IBC is overseen by though the board is oversee the process of insolvency process, but these CoC members, who are generally the bank, they are outside the purview of IBBA. As a result of which, there is no clear-cut guidance for them how to handle because RBI, there is no guidelines or procedure is there from RBI saying how to handle the IBC cases. So as such, to foster more effective and time-bound decision-making by the CoC members, these guidelines means the guidelines which they have issued on 6th August 2024 have been issued to stem the value erosion through curtailment of procedural delay and enhancement of transparency and coordinated approach of decision making by the members of CoC. This is as per the as per Insolvency and Bankruptcy Law, IBBA. CoC members are now mandated to follow the relevant provisions of the code in both letter and spirit, maintaining objectivity and integrity in their decision-making process. So board wants that they should follow this in letter and spirit, this code of conduct. Guidelines would help in resolution under the code in a time-bound manner in the interest of maximization value of assets of the city. So if you see the guidelines, it starts with the objectivity and integrity. It says that follow the relevant provisions of the code and regulations in letter and spirit. It says that through this code of conduct that the core provisions in the code and regulations should be followed by the CoC. Their roles and functions, maintaining integrity in discharging their roles and functions as envisioned under the code. Okay, just a minute, please. I have to take this one. Sorry. Maintain objectivity during the decision-making process, foster informed decision-making, and share with CoC insolvency professional any relevant information relating to transactions, guarantees, recoveries, claims, etc., relating to the corporation. So, not only this, as per this code of conduct, not only the bank will share or the CoC members will share this information with the insolvency professional, but code says that they should share with other CoC members also. You know that when the application is filed a bank now, who has given the loan, but subsequently through that paper advertisement, other banks also who have that exposure, they file these things. So it is the responsibility of the applicant to share all that, not only the applicant, all the CoC members, I think. They should share the information with each other and also with the insolvency profession. Independence and impartiality. Disclose to the CoC insolvency professional details of any existing potential conflict of interest arising due to pecuniary, personal, or professional relationship with the stakeholder immediately on becoming aware of. We have already seen that as per the provision of the code, related party should not be a member of the CoC in order to promote the proper decision of the CoC. So maybe at the time of his inclusion in the CoC, it is not there, but subsequently he has become interested or he has become a related party. That should be disclosed. Not only to the insolvency professional, but to the CoC as a whole. Professional competence and participation. Keep themselves updated with the provisions of the code. This is very, very important. If you see, I am sure that all of you have faced this thing. The main issue comes because, again, I am sorry for this, but I have the experience that because of the, lack of knowledge of the CoC members who is attending the meeting of the provision of the codes. I'm sorry, but I don't have any other language to express my view. So code says that the provisions of the code should be known to the member who is representing as in the CoC. Rules, regulations, and the role and responsibility assigned thereunder. Nominate representative with proper authorization and sufficient mandate to effectively participate in meetings. The nominated representative may endeavor to obtain approval of the competent authority if required at the earliest. Again, that issue, we will get back to you after internally discussing this. So they said that it should not be. Participate actively, constructively, and effectively in deliberations and decision making of the CoC. Cooperation, supervision, and timeliness. supervise and facilitate the insolvency professional in discharging his duties under the code, facilitate expeditious appointment of various professionals within the timelines prescribed under the code of regulations. I have discussed with you the problem with appointing the transaction auditor or the forensic auditor. So in order to overcome this problem, this code says that as far as possible within the time frame, they should provide the approval. Endeavor to resolve any interstate dispute between the members, particularly in relation to claims, preferably through dialogue or other non-adversarial means, with a view to avoid litigation to the extent possible. Mr. Vaidya said that now, what is that? Minority financial creditors. So, court suggests that if you apprehend that any such issue comes, you settle it beforehand. Otherwise, you should not land up with the legal battle on this account, at least within the CoC members. Ensure at all times complete adherence of the undertaking regarding confidentiality of information. Take necessary measures to ensure that insolvency resolution process cost is reasonable, and expeditiously decide on all the expenses to be incurred by the insolvency professional, including the going concern expenses of the corporate debtor and his fees. Prudently fix the fee payable to the liquidator while deciding to liquidate the corporate debtor. This is also another very, very important. Friend, again and again, I'm telling that if you go through this code of conduct, you will understand the deficiency generally we see in the commercial wisdom of this. I have faced this thing that, okay, the CoC has approved the liquidation. CoC has recommended for the liquidation of the corporate debtor, but as per the code, the CoC should also approve the estimated budgeted cost. Okay. Subsequently, it also requires not approval, but should be discussed with the stakeholder committee members. But prima facie, as per the code, the CoC should also approve the estimated liquidation cost and the fees to be paid, whether it is based on the percentage or it is a per month payment, lump sum payment per month, but it is not done. They only said, okay, it will go to liquidation. All these things, lead to the time-consuming efforts. Cost for cost, liquidator has to make his budget. Again, he has to call a meeting of SCC, ask them that you have any view on this. Had it been done at that stage, when CoC is approving the liquidation of the corporate debtor, all these things can be avoided. And according to me, all this comes under the purview of the commercial wisdom. Very definition of the commercial wisdom is the quality to give judgment on the matter, isn't it? Meeting of CoC regularly monitor the activities of the insolvency professional and seek rationale of decisions, actions taken by him. Diligently recommend for the inclusion or otherwise of the belated claims collected by the insolvency professional and categorized as acceptable in the list of creditors and its treatment in the resolution plan, if any. actively participate in the presentation of valuation methodology made by the registered valuers. Now, it is the mandated to the RP. Earlier, what's happened? RP engage the valuers submit the report, and then RP discuss the report with the CoC, provided RP got the non-disclosure document from the CoC. But now the code, the regulation said that it is the RP should conduct a meeting at the time of appointment of the valuers, where the valuer will discuss about its methodology to value the corporate data. Though valuers is not bound to take the advice, is not to go by the advice of CoC, but definitely CoC has the scope to make the recommendation to the valuers. So this code really, in this code it mentioned that actively the CoC should actively participate in the presentation of valuation methodology, so that a proper valuation can be achieved. Ensure the code of meeting at regular intervals as specified in the conduct of the meeting at regular interval as specified in regulation. Then sharing information, proactively share the latest financial statements. Really, it is a problem till now. Relevant extract from the audits of the corporate data conducted by the creditors, such as stock audit, transaction audit, forensic audit, etc., and other relevant information available with the insolvency professional to enable efficient conduct of the process. Seek details of all litigation filed against or by the corporate debtor from insolvency professional and recommended necessary actions to insolvency professional to safeguard the interest of the corporate debtor. Feasibility and viability of the corporate debtor. Carefully review and assess the information memorandum prepared by the insolvency professional and offer additional insights. It's a very, very important thing. And really it requires the commercial, that it should play in its commercial wisdom in approving the information memorandum. Information memorandum is the document, as you all know, where the each and every aspects related to the corporate data should be mentioned. And based on this document, generally the PRA, prospective resolution applicant, submits their plan. Any deviation, any non-disclosure of facts in the IM will lead to litigation. And there are many cases on this. So courts say that it is not only the responsibility of RP, equally corporate CoC should assess these things and provide additional insight on this document. Sorry. Feasibility and viability of corporate data will contribute to the preparation of marketing strategy of the insolvent professional by the insolvent professional, and also may also take measures for marketing of the assets of the corporate data if necessary. Ensures that all resolution plans are received by the resolution professional as placed before CoC. Suitably consider the requirement of monitoring committee for the implementation of resolution plan. This is mainly, I think, according to me, mainly applicable for the real estate projects. Generally, the CoC should approve whether the resolution plan will be invited for the corporate data as a whole, or it should be project-wise, which will give more marketability to the PI. Maybe the corporate data has a project in Kolkata, another in Delhi, other in Bangalore. In that particular case, asking for the resolution plan as a whole may not be a feasible proposition. Whereas asking resolution plan for Kolkata project, for Delhi project, for Bangalore project, maybe many peers will be affected out of that invitation. So it is the responsibility, or it is, and again, you will appreciate that this becomes the commercial wisdom of CoC. How to go about it. So these are the guidelines of IBBI for CoCs issued on February 2024, 6th February. Let's see how this will improve. So I am pageant of my presentation. In summary, I want to say that the commercial wisdom of CoC is a paramount function enabling them to exercise their powers, which goes in line with the preamble and the sacrosanct order of the objectives therein. So the commercial wisdom of CoC fulfills both the preamble. We have read the preamble and the order of the objectives. That also we have seen. So both the things can be achieved through the commercial wisdom of CoC. The AA has been in excess of its jurisdiction in certain cases, holds the power of CoC, but apex court in most of the cases uphold the vision of legislation, that is, uphold the commercial wisdom of CoC. Indian judiciary, by providing prima facie to the commercial wisdom, has unlocked unlimited power of the CoC. Everywhere in the code, many, till now the codes are amended to provide the more power in the hands of CoC so that they can play the commercial wisdom, both from judiciary and also from the, as well as from the legislation. Because it is a very, very important and should be played very carefully. The commercial wisdom of CoC cannot be put into question. Absolutely. I also agree. If the court say that, okay, I have given you the power to play your commercial wisdom to run the insolvency process, I personally feel it is very, what should I say? I mean, very remote. It should be very remote to raise questions on this, because they have obtained this thing out of the code, out of the legislation. This is because the committee of creditors are considered as the detriment factor with the duty of maximization of assets, as well as ensuring the balance between the rights of stakeholders. I will say that, no, I consider this because CoC has earned these things out of the code, out of the legislation. So questioning their commercial wisdom, I think it is, I'm not in support of that. If the time and situation demands more stringent, so for that, if the time and situation demand, more stringent practices can take place, again to ensure that the mechanism can run efficiently. So, instead of questioning their commercial wisdom, I'm of the view that more stringent practices can take place or can be embodied in the code, so that we can have the effective commercial effective part from the CoC by playing their commercial wisdom, by which the insolvency process can be run effectively or efficiently. Okay. So I think this is the left side. Yes. So I am through my presentation. If you have any question, you can ask me. What is the time? So we have 5 minutes more. Any question? If you want to share your experience, because commercial wisdom, again, I'm saying it is a very subjective matter. Definitely it depends. I mean, I have some experience, you have some experience. Other may also have some other experience. So if you want to share your experience on this, or if you have any suggestion, any recommendation, that look, this should be handled in such a way so that we can have the more effective insolvency resolution process. Friends, you are free to discuss. Nothing. No one will volunteer. No personal experience, no reference, no case laws, on this subject, which I have not touched upon. Or if you feel that the way I have interpreted the case laws, maybe you have some other, you can freely discuss it. So, sir, I think this will be, I mean, this is the actual interpretation of this case law. Anjali, you are here. Hello. Anyone from ICSI, IIP?
Yes, sir.
Yes, Anjali. Anjali, I am through with my presentation. I think we have
Can we conclude, sir?
Yeah, I think, I mean, if nobody has any question or I don't know, I ask them, I mean, if they have any question or if they want to share their experience, they can do it.
Okay.
So,
Then we can conclude, sir.
yeah, yes, please.
Thank you very much, sir, for giving your valuable time
Thank you.
and
Anjali.
sharing your knowledge regarding the topic, commercial wisdom of CoC. Sir, you are requested to please share the material you have present.
I think there is no question in the chat box.
So you can share on my email.
No question. Yes, I'll share. Anjali, I shared my PPT with you. Sure.
Yeah, sure, sir.
Sure. So I take your permission, friends.
Yes, sir.
I am just leaving the site. Okay. Thank you
Okay.
once again for your participation. Thank you once again, Anjali, for your invitation. Thanks a lot.
Pardon, sir?
I thank all the participants for their participation. I also thank you for your invitation.
Thank you very much, sir.
For your invitation to speak in this. Okay. Good.